Welcome to the Deep Dive. Today we're going to tackle a really important topic here in California, the eviction process.
Yeah, it's a tough situation, definitely, for everyone involved, whether you're the tenant or the landlord.
Absolutely. And what we want to do today is walk through the steps involved when a landlord actually needs to pursue an eviction. Legally, it's called an unlawful detainer action.
That's right. And it's a very formal process, very step-by-step. You got to follow the rules precisely.
So for this deep dive, we're drawing on California law, some guides from the Department of Real Estate, info from the California Court's website, and even some, real-world property management perspectives.
Right. The idea is to map out what a landlord is looking at if they find themselves needing to go down this road.
Okay, let's jump right in. Say a landlord has a tenant who isn't paying rent, or maybe they're breaking the lease somehow. What's the absolute first legal move?
The first thing, and it's critical, is serving a formal written notice. This isn't optional. It's step one.
This tells the tenant what the problem is, right?
Exactly. It clearly states the violation, like not paying rent, and what the tenant needs to do to fix it, and by when.
And for that classic scenario, unpaid rent, what's the usual notice called?
That's typically the notice to pay rent or quit. It basically gives the tenant a set period, usually 3 days in California. Though, like we said, check local rules to either pay up the full amount owed or, well, move out, quit the premises.
And while there are other notices for different lease issues, the key is always having that legal reason and the correct written notice first.
Absolutely. You can't just, verbally tell someone they're being evicted. It starts with that formal paper trail.
And delivering it isn't casual either, is it? You can't just slide it under the door.
Definitely not. The law is very specific here. The best way is personal service, actually handing it to the tenant.
Okay.
If you try that a few times and can't manage it, you can use substitute service. That means leaving it with another adult at the property, someone who seems responsible, and then you also have to mail a copy to the tenant there.
Mail a copy too. Okay.
Yes. And the third option, if the first two don't work, it's called post and mail. You post the notice somewhere obvious, like the front door, any you mail.
And for all of these, you need proof you did it right.
Crucially, yes.
Yeah.
You have to fill out a proof of service form. Think of it as your documented evidence for the court, showing exactly how and when that notice was delivered. Without it, your case could stall later.
Gotcha. Okay, so notice served correctly, proof filed, but the tenant doesn't pay, doesn't fix the problem. What's the landlord's next legal step?
All right, if the tenant doesn't comply within that notice period, the landlord's next move is to go to court. They file an unlawful detainer lawsuit.
Okay, so this is where it becomes a formal court case.
Exactly. This is the landlord officially asking the court system to step in and order the tenant out.
And there's a specific form for this, the UD-100.
That's the one. The Complaint Unlawful Detainer, Form UD-100. It's the document that gets the ball rolling in court.
What kind of information does that form require? Seems like it would need a lot of detail.
It does. You need the basics, like landlord's name, plaintiff, tenant's name, defendant. You also have to specify if it's a limited or unlimited civil case. That usually depends on how much money is involved.
Okay.
Then you detail the rental agreement. Was it written, oral, how much rent, when was it due? And crucially, you state the exact reason for the eviction, like failure to pay rent for May, for example.
And you have to mention the notice you served.
Absolutely. You describe the notice type, how you served it, and you attach a copy of that proof of service we talked about. It all connects back.
Makes sense. And what is the landlord actually asking the court for in this complaint? Just getting the tenant out?
Primarily, yes. They're asking for possession of the property. But they can also ask for other things.
Right.
Like the past due rent, court costs the money spent filing the case. If the lease allows it, they might ask for attorney's fees too. They might also ask the court to formally terminate the lease. That's called forfeiture of the agreement. And maybe damages if the tenant stays beyond the notice period. Sometimes even statutory damages for a certain bad behavior, though that's specific.
Right. And you mentioned this UD-100 isn't for evictions after, say, a foreclosure sale.
Correct. That's a different scenario. Different forms usually apply there. This is mainly for lease violations or non-payment during a tenancy.
Okay, complaint filed. Now the tenant needs to officially know they're being sued. How does that happen?
Right. So after filing, the landlord has to arrange for the tenant to be served again. This time they get a copy of the filed complaint and a summons.
A summons? What's that exactly?
The summons is the official court paper telling the tenant they've been sued, how long they have to respond, and what their basic rights are in the lawsuit.
And I'm guessing the serving rules are just as strict for these court documents.
You bet. Same basic methods apply as with the initial notice. Personal service is preferred, hand it directly to the tenant. If that fails after trying, then substitute service leave with another adult at home, plus mail a copy.
Right, leave and mail.
Yep. And then there's post and mail, but for the summons and complaint, you generally need the court's permission first before you can just post it on the door and mail it.
Ah, okay. Need court approval for that method here.
Usually, yes. It's a less preferred method for these crucial court documents.
And once the tenant is served, there's a deadline for them to respond, isn't there? What if they just ignore it?
There is. It's pretty tight. If they're served personally, they typically have only 5 calendar days to file a formal written response with the court, usually called an answer.
5 days. Wow, that's fast.
It is. If service was by substitute or post and mail, the clock starts ticking a bit differently because of the mailing time involved. Usually they're considered served 10 days after the mailing, then the response time starts. So it gives them a bit longer overall.
Okay. And again, proof of serving these documents is needed.
Absolutely critical. The landlord needs to file another proof of service, the POS 010 form, telling the court exactly when and how the summons and complaint were served on each tenant. This is vital if the tenant doesn't respond.
Which leads to my next question. What happens if the tenant files that answer? Does it automatically go to a big trial?
If the tenant files an answer, yes, the case is typically set for trial. And the courts try to move these unlawful detainer cases quickly. Usually the trial date is set within about 20 days after the answer is filed.
20 days? That still seems pretty quick for a court case.
It is, compared to other civil cases, but keep in mind there can be delays. Either side might file motions, or there might be some back and forth discovery gathering evidence, which can push the trial date out.
Okay. But what if the tenant doesn't file an answer within that time frame? They just missed the deadline?
If the tenant fails to respond after being properly served, the landlord can then ask the court for a default judgment.
Meaning they win automatically because the tenant didn't fight back.
Essentially, yes. The landlord requests the court to rule in their favor by default. If the judge agrees and grants the default judgment, the next step is usually issuing a writ of possession.
Writ of possession? That sounds like the end game for getting the property back. What is it?
It is. The writ of possession is the actual court order telling the sheriff to remove the tenant and give possession of the property back to the landlord.
So the landlord gets this paper and then...
The landlord takes the issued writ to the local sheriff's department. The sheriff's civil division handles evictions.
And the sheriff just goes over immediately.
Not quite instantly. First, the sheriff will typically post a notice on the property, usually a 5-day notice to vacate. This gives the tenant one last chance, 5 days, to move out voluntarily.
Okay, a final warning period.
Exactly. But if the tenant is still there after those 5 days are up, the sheriff will return.
And that's the actual lockout.
That's the lockout, yeah. The sheriff comes back, physically removes anyone remaining on the property, and the landlord usually meets them there with a locksmith to change the locks immediately and secure the place.
Wow. So from that initial 3-day notice to the sheriff actually showing up for the lockout, that sounds like it could take quite a while.
Oh, absolutely. It's definitely not a quick fix. Depending on how things go, if the tenant fights it, court backlogs, etc., you could be looking at anywhere from maybe a couple of months to realistically 3 or 4 months. Sometimes even longer.
3 or 4 months. And I imagine this whole legal ordeal isn't cheap for the landlord either. What kind of costs are involved?
No, it's definitely not cheap. You've got the initial court filing fees, which, might be somewhere between $250 and $450, roughly, depending on the county.
Okay, that's one cost.
But honestly, the biggest hit for most landlords is the lost rent. If the process takes 3 or 4 months and the tenant isn't paying during that time, that adds up very quickly. We're talking potentially thousands of dollars.
Yeah, that sounds like the most painful part financially. And even if the landlord wins the case, getting that back rent must be tough.
It can be very tough. You might get a judgment saying the tenant owes you that money, but actually collecting it is a whole different challenge. Often, landlords only recover a small fraction, if anything, especially after maybe paying for collection efforts. It's frustrating.
Definitely sounds like it. Now, we saw something mentioned about a pre-trial settlement conference. What's that about?
Yeah, that's often a step the court encourages, or either party can request it. It's basically a meeting before the actual trial date where the landlord and tenant, maybe with a judge or mediator, try to work out a deal.
Like a last chance to resolve it without a full trial.
Exactly. Maybe they agree on a move-out date, maybe a payment plan for some of the owed rent. something to avoid the time and expense and uncertainty of a trial.
So if a landlord goes to one of these conferences, what should they absolutely bring?
Oh, definitely all their paperwork. Copies of the lease, the notices they served, the proofs of service, records showing the non-payment, maybe photos if it's about property damage. Basically all the evidence backing up their case. Being organized really helps in those negotiations.
Makes sense. And navigating all this, California eviction law seems notoriously complex, right? We saw some strong opinions on needing a lawyer.
Yeah, that came through loud and clear. California law does have a lot of specific requirements and, frankly, many procedural protections for tenants. It's very easy for a landlord, especially one doing it themselves, to make a small mistake.
And a small mistake can derail the whole thing.
It really can. A mistake in the notice or how it was served or in the court filing, it could get the whole case dismissed, meaning the landlord has to start all over again, losing more time and more rent. So while hiring an attorney costs money, many landlords find it's worth it to avoid those costly errors and delays. An expert can navigate the system properly.
That's a good point. And speaking of advice, there was also a warning about just relying on, stuff you read online.
Absolutely. You see advice on forums, websites. Some might be okay, but eviction law is so specific to the location and the exact situation. What worked for someone else might not apply, or the law might have changed.
So double check everything with a real expert.
Definitely. Check with an attorney or use resources from the official California court's website or local legal aid if you're a tenant. Relying on random internet advice for something this serious is pretty risky.
Okay, so let's try to quickly recap the landlord's journey here. It kicks off with a proper written notice, like pay rent or quit. If that doesn't work, file the UD 100 complaint in court.
Right. Then serve the tenant properly with a summons and complaint. File that proof of service.
Then the tenant either responds, potentially leading to settlement talks or a trial within about 20 days, or they don't respond.
If they don't respond, you request a default judgment and hopefully get that writ of possession,
which you take to the sheriff, who posts a 5-day notice and then, if necessary, performs the lockout.
That's the basic path, yeah. And remembering it can take months and cost quite a bit, especially in lost rent.
And settlement is often worth exploring, and given the complexity, getting legal advice seems really wise for landlords navigating this.
Couldn't agree more. It's a legal minefield if you're not careful.
Absolutely. And it really drives home the point that communication and trying to resolve issues before it gets to this stage is probably best for everyone involved, if possible.
Yeah, exploring all those options first can save a ton of headache, time, and money down the line.
Definitely something we saw emphasize. Well, this has been really illuminating, digging into the landlord side of the eviction process in California. It's clearly a formal, complex legal path.
It really is. Understanding these steps is crucial for anyone involved in property management or renting in the state.
For sure. And for our listeners, particularly tenants in Orange County, Riverside, San Diego, or Los Angeles who might be facing an eviction, just a note that the Martinez Law Center in Santa Ana specializes in representing tenants in unlawful detainer cases, as well as other areas like real estate partitions and accidents in apartments. You can find them at martinezlawcenter.com. Again, they represent tenants.
Good to know those resources are out there.
Definitely. So, wrapping up, it leaves us with a thought. Considering all these complexities, the costs, the time, what strategies can both landlords and tenants really prioritize to prevent things from ever reaching the point of a formal eviction in the first place? Something for you to think about. Thanks for joining us on this deep dive.
Thanks, everyone.
We'll catch you next time.
Call now 714-442-9741. Thank you.